Hey everyone, and welcome to our video today. Today we're going to talk about custody issues in early education programs. Hope y'all are ready for this very important conversation. This is a conversation we have had many times in the past, but we've got some brand new language that has been added to the child care minimum standards. So I'm going to show you how you can tie these difficult conversations into meeting the child care minimum standards and how to adapt these rules into your personnel policies. We want you to be focused on the care and the education of the children in your program and not pulled away and distracted by families' personal custody issues that tend to want to linger into our programs and occupy a lot of our time. If this is your first time watching one of our videos or participating in our Facebook Lives, welcome. We are super glad that you are here. This training has been submitted to TechPEDS, the Texas Early Childhood Professional Development System. So make sure that your personal TechPEDS ID number is entered on your Tim the Trainer profile before you complete your assessment. That way your certificate will automatically be uploaded into your TechPEDS account. That is very helpful for you, especially if you're going through Texas Rising Star, maintaining your annual training hours. It's just a really good process for you to practice. Make sure that you know that if you have any questions about the material that we're covering today, you can always reach out to me. There's 3 different ways that you can get a hold of me. On our website, timthetrainer.com, up in the upper right-hand corner, you can send me a direct message with any questions that you have. You can give me a call or you can shoot me an email. If you've got questions about this training material or if you need more information beyond the scope of the training, and I can respond to you in a timely manner to give you feedback, answer your questions, give you any type of guidance. For this particular topic, custody issues, if you do have something that is going on in your school that you need some guidance and coaching in regards to custody, please give me a call. I'll be happy to help you to the best of my ability, or I can refer you to legal counsel if that happens to be the situation that is needed. All right. Now, if it's your own personal custody situation, I would rather not get involved in that. Let's stick to what's going on in your business, in your school, and we can definitely coach and guide you there. So let's talk about our learning objectives for today's training. Here's what I really want to focus on and for you to be able to take away from. Participants will learn and understand the expectations for court orders that is outlined in the Texas Child Care Minimum Standards. I'm going to show you that and give you some guidance there. We're going to review sample policies on custody disputes and how to implement these into your program. Make sure, remember again, if it's not written down, it didn't happen. So lots of documentation, making sure that you've got policies and processes in place to be proactive to any type of situation that you might have in your program. And then also just go over the rules and the laws that we have in the Texas Penal Code for parents' right to access. You're going to kind of see this embedded in the child care minimum standards as well. All right, so let's just start off a little bit with some biology class here. This is not new to anyone, but for every child that's out there, there was a mother and a father that created that child, okay, in most situations. Now, you could have a single parent adoption. You could have a donor situation, an artificial insemination. There are situations where only one parent's name is listed on a birth certificate. absolutely, you could have some of these situations. They're pretty rare, but sure. For the most part, there are two biological parents in every child's situation. There was a sperm and there was an egg that made that child. All right. Kind of keep that in mind because it is our role managing your business to suspend judgment. All right. And when it comes to dealing with custody situations, you want to look at facts and facts only. What do you have in writing? What do you not have in writing? Who is the biological mother? Who is the biological father? Or what is written in the court order? All right. Other than that, listening to a family's story, creating judgment, creating opinions, all right, creating, those type of things, that's completely irrelevant. And that's going to do nothing but make the situation worse, all right? I know that sometimes the families want to come in and they want to tell you the whole drama, the whole story, why they're no longer together and this person is primary, this person is secondary, or why they're joint or shared. Y'all try to avoid getting involved in those conversations. Provide me with the certified copy of the court order. We're going to follow the court order exactly as written, but it is not our role to create judgment, all right? And that's hard to do sometimes. Anytime you have a family that comes in and they want to spill the beans and tell you their whole story, always remember, there are three sides to every story. There's this side, there's that side, and the truth is usually muddied in the middle somewhere. So if you have a biological mom coming in and wanting to tell you a story, y'all, I can guarantee you there's another side to that story. All right? They're only going to tell you the bits and pieces that they want you to know. Okay? So this takes a lot of practice. It takes a lot of experience, right? So my recommendation to you in your policy manual, and like bold print underline in your policy manual, in the absence of a court order, both biological parents have equal rights. Does not matter who enrolled the child. Does not matter whose name is or is not on that admissions form. Does not matter who's paying the tuition. Doesn't matter who's dropping off or picking up. All of that is irrelevant. In the absence of a court order, both biological parents have equal rights to that child. If you have a parent that turns in an enrollment form or admissions form and they leave one of the parents' information completely blank, right? If that person shows up at your school with a picture ID and a birth certificate proving that they're a biological parent, by law, they have a right to access. Okay? So, it's really important for you when you're collecting enrollment paperwork, make sure that the paperwork is completed. If there's anything left blank, you need to return it to the family and say, hey, you need to finish this, fill in the blanks right here. Okay? I always kind of sarcastically say, if we didn't need the information, we wouldn't be asking for it. Okay? If we're asking for it, that means we need it. You don't get to pick and choose what parts of the enrollment paperwork you fill out and what parts you leave blank. All right? If they come back and they say, Dad is not in the picture, all right? Well, I still need the most recent information you have on Dad, and I need that filled in, okay? Because if he were to show up with a state-issued ID, a picture ID, and a birth certificate, and there's no court order on file, technically he has a right to access that child. You don't want to get yourself in that position. Okay, and we're going to talk about that a little bit more in this presentation. Again, in your policy manual, in the absence of a court order, both biological parents have equal rights. I cannot stress that enough. What I really like to see on your enrollment form or admissions form, whatever you call it, I like it when you have a line that says something like, biological parents, biological parent 1, name, address, phone numbers, biological parent 2, name, address, telephone numbers, etc. And then I like it when you have a line that says something like, is there a court order on file for this child? Circle yes or no. All right? And then they have to circle yes or no. If you circle yes, a certified copy of the court order must be attached. All right? That's what I really like for it to see in these situations. If they circle no, then you know that there's no court order. Both biological parents have a right to access. If they circle no, and then a month or two later they come back and they say, oh, well, dad can't access the child. Well, you said that there was no court order on file. So it could be that they falsified a legal document. What I've also found to be really helpful on that enrollment paperwork, where you say, biological parent 1, all of their information, biological parent 2, all of their information. Is there a court order on file? Circle yes or no. And then right underneath that, I like it when you put this statement. In the absence of a court order, both biological parents have equal rights. Period. And when it's right there on the enrollment form for them to see, when they're filling it out, y'all, it makes a big difference. Okay? If you just put it in your policy manual, that's good, but it's not enough. Because y'all know as well as I do, they don't always read those policies, right? But when they're filling out the enrollment form, they're going to see this. So that is a really strong recommendation for you right there. Now, let's look at what has been added into the child care minimum standards. And y'all, this is good, all right? This is a celebration. This is a win, because this just gives us more backup, all right, in handling these difficult situations right here. And there's 2 different pages that I'm going to show you that are going to be really good for you managing your program. So first off, when we look at 746-521 under the parent rights, all right? So number 6 on the parent rights, have your center comply with a valid court order signed by a judge that prevents another parent from visiting or removing the child from your center. All right? And remember, we are required to share the parent rights with the parent or guardian upon enrollment. Whether you include this in your policy manual or if you use the separate handout to give the parent their rights, whichever works best for your program. You can download this from Child Care Licensing's website and have the family sign it upon enrollment, whichever, okay? But you can also cut it and paste it into your policy manual and then get the signature with the acknowledgement form. Either way, you're getting backed up from Child Care Licensing about having the court order and that you have to have that on file, especially if it's preventing one of the biological parents from accessing the child. The other page that is going to be really helpful to you is under release of children. So this is 746-4101, to whom may I release a child? And you can see B as in boy right here. Upon receipt of a valid court order signed by a judge that prohibits a parent from removing the named child or children from the program. Okay, you must comply with the court order immediately and until a new court order has been provided to you, or until the court order expires. And then you must maintain a copy of that court order in the child's file. So y'all see, this is right here in the Child Care Minimum Standards. So once again, if there is a court order on file for that child, you must have a certified copy. Okay? Not just for the protection of the child, the protection of your business, but to be able to meet minimum standard expectations, you need to have a copy of that court order. If you have a family that refuses to provide you with a copy of the court order, then you don't accept the enrollment. All right? Or you suspend enrollment until that document is provided to you. And y'all, this is one of these topics where you kind of have to put your big boy and big girl panties on, and you got to stand your ground. All right? Remember, parents don't run your business, you do. Okay? So if they're refusing to bring in those court orders, you don't allow the child in until you get it. Okay? You got to make sure you're protecting yourself and staying in compliance. Now, there's something else on this page that I want to point out that is a little tricky, and I want you to be really careful with this right here. If you see under the technical assistance box, and you know this is not a standard or regulation, this is just technical assistance, but in that second bullet point, you may not legally prevent the child from being picked up by a parent or a person designated by the parent. So that goes back to the Texas Penal Code. You cannot prevent a biological parent or their appointee from accessing that child. However, you may address this issue at enrollment by asking the parent how they would like for you to handle a situation where you don't feel comfortable releasing that child to that person and then having the parent sign that agreement. Y'all be careful with this one because this is going to be one of those catch-22, damned if you do, damned if you don't situations. Just because you create this agreement and it is signed by one parent does not bypass the court order, and it does not bypass the law that a biological parent has a right to access. Okay? So in my opinion, this bullet point under technical assistance could actually cause you more trouble than it could be helpful. All right? Basically, what I would do in this situation is that if you do have a court order on file and there is a situation that comes up where you don't feel comfortable, you may outline in the agreement that your process is to call local law enforcement and have local law enforcement come to the center to make that call on whether or not the child was released to such person. So kind of take the decision making out of your hands, all right? But as far as preventing the child from being released to a biological parent, that can get you into some trouble, so be careful with this one. Okay, I'm not telling you to ignore that technical assistance. I'm just telling you to be careful with it. All right, so keep that in mind. All right, so the thing about court orders nowadays is they're pretty simple documents. It's not like it used to be, 25, 30 years ago where every single court order said something different and it took a lot of time and energy to review these. Nowadays, they're pretty standard documents. They're pretty fill-in-the-blank documents. Unless you have an extenuating circumstance, they all kind of say the same thing. You either have a shared or joint custody situation where biological mom and biological father or biological parent 1 and biological parent 2, have that equal decision making, equal custody. It's kind of a 50-50 situation. You could have a sole or exclusive custody situation where one of the biological parents is primary, the other one is secondary. You might see a sole or exclusive custody situation from time to time. Most of them are going to be shared or joint, right? And it might say something like, mom has the child, during these days, dad has the child on Wednesday and every other Friday, or however the language is written. And if that's what the court order says, then that's what you follow. Okay? And if it says something like dad can pick up on Wednesdays and every other Friday, mom cannot call on Tuesday and say, well, I like dad this week, I'm going to let him pick up. Unless mom is a judge, she can't make those decisions. You have to follow the court order exactly as written. All right? Now, with that being said, you're probably not going to run into too many of these situations. Most of the court orders these days will say something like, mom is primary, dad is secondary, dad can pick up on Wednesdays and every other Friday. And then it's usually followed with a sentence that says something like, unless both parties mutually agree on a change. And as soon as it says, as long as both parties mutually agree on a change, that kind of makes it a wide open ball game. And I'm going to say about 95% of the court orders that you get a copy of, that's usually what they say. All right? So again, this is a lot easier than it used to be. Okay? Make sure that you're getting certified copies from the court. All right? Not something that's been doctored up or fixed up by the parent. Needs to be that certified copy. The other thing that I'm going to stress to you right here when we talk about shared or joint custody situations, all right? In most situations, all right, whether it's primary or secondary, whether it's shared or joint, it will typically always say something like both parents have a right to make the decision based on health, education, religion, culture, beliefs, and convictions. Both parents get decision-making authority. And again, most of them that you see are going to say this. It's very rare that you see a court order where one particular biological parent doesn't have decision-making authority. Okay, I have seen them before, but they're very extreme circumstances. Now, with that being said, all right, this is what you want to put in your policy manual, and this is what you want to address at the time of enrollment. Mom and dad, or biological parent 1 and biological parent 2, need to make these decisions together at home and communicate their shared decision with you. All right? You don't want to get into situations where mom is giving you one set of instructions and dad is giving you a second set of instructions, right? Like some of the most common things we see is, dad wants to add his new girlfriend to the pickup list, and then mom is going, oh, no, I don't want her picking up my kids. All right? Hey, you know what? Mom and dad, y'all need to have this discussion at home. And you have until Friday to give us a mutual decision. This adding names and taking off names and going back and forth and playing serve and return, the tennis match, we're not going to do that. All right? I had a situation one time with an infant. Mom wanted to fill out a new infant feeding instruction form and have us start introducing table food. Dad comes in and rips it up and fills out another one and says, no, the child is not ready for table food. Mom comes in the next day and is like, hey, I told you yesterday, start introducing table food. And so we were getting conflicting instructions from the two biological parents. Well, we ended up having to get on the phone and say, hey, Mom is giving us one set of instructions. Dad is giving us another set of instructions. Y'all have until Friday to get together at home and come up with a mutual decision that both of you agree upon. If y'all cannot give us consistent instructions by Friday, then we're going to suspend care until you can get it together. All right? But stress that this decision making has to take place at home. Take yourself out of the middle of it. All right? We're not going to get involved in that. Okay? So really important for you to be able to use that language as well. And again, I like it when this is spelled out in your policy manual. All right? Decisions on health, education, authorized pickups, all of that stuff needs to be decided mutually at home, and that decision given to the Center for Implementation. Okay? But we're not going to get into the ping pong match with directions going back and forth. So that kind of leads us into record keeping. I know that I've already talked about the admissions form, making sure that that is filled out completely or to the best of the biological parent or guardian's ability. All right? I totally understand in some situations there's going to be some absent information based on that circumstance. But again, that's pretty rare. Usually, responsible party 1 has information on responsible party 2. If you do have a parent that turns in incomplete paperwork, you need to sit down and have a conversation about that. All right? But try to get as much as you possibly can get. The biggest thing is, like I said, the authorization to pick up. Now, if it's a shared or joint custody situation, what I have done in the past is I will give Mom an enrollment form for her to fill out, and she can put down her information. She can put down her authorized pickups. You give Dad, or parent number 2, give them an admissions form. They fill it out with their information. They authorize who they want to authorize. And then when it's biological parent 1's day to drop off and pick up, you follow their form. When it's biological parent 2, when it's their day, you follow their form. Okay? I don't like having to do that. It's not the ideal situation, but sometimes that's what we've had to do. And each parent doesn't have a right to alter each other's records. Okay? Same thing with emergency contact. If they cannot mutually decide on an emergency contact that can be reached when either parent cannot be contacted in an event of an emergency, then parent 1 designate their emergency contact, parent 2 designates their emergency contact. And whoever's day it is, that's what you follow. Okay? Hopefully you can get the two parents to mutually agree on that emergency contact. That is the cleanest and best way of doing it. And then you've got those consistent records right there. Again, when we talk about visitation, most of your court orders are going to say, this person can pick up on these days, this person can pick up on those days, unless they both mutually agree on a change. This is where, when we talked about that agreement that's in the child care minimum standards under technical assistance, This is where I would get this in writing, is any other time when they mutually agree upon a change, outline that. Okay, kind of figure out what that agreement looks and feels like, and then get both parents' signatures at that point in time. All right, now that's how I would handle that. The other thing that needs to be addressed is sometimes we have custody situations where one of the biological parents wants to come and visit the child while they're at your program. Not necessarily pick them up or take them, but they just want to come up and visit. All right? Now, again, we're going to refer to the court order and any language that may be outlined in the court order as far as visitation. You definitely want to make sure you're not violating anything that's in the court order. But then from a business standpoint, is that visitation going to interfere with your ability to operate your school? Is that parent visiting that child distracting the classroom or interfering with the child's ability to be educated? If the parent is wanting to remove the child from the classroom, that would require them to sign the child out. So that way you don't have the responsibility of the supervision, right? If you allow that parent to take the child out of the classroom, that could create a ratio and supervision issue. So does the parent have the right to sign the child out to visit them at your program at that point in time? So you can see there's a lot of moving parts right here that have to be looked at. Then you got to ask yourself, if you're allowing that visitation to take place at your facility, what are you getting yourself involved in? And is that visitation placing the rest of your school at risk? Why can't this visitation take place outside of the school? And you kind of have to ask yourself that question. Why isn't this parent visiting the child when they're away from the school? Why do they feel like they need to do it here? And is that something that you need to remove yourself from? All right? The good news here, most of the time, the language in the court order is going to help solve this problem for you. You're just going to need to do a little bit more work on that. Now, here is the slide that's a little uncomfortable. All right? When we talk about confidentiality, okay, technically, step parents and grandparents have no legal rights, all right, unless you have a court order stating otherwise, okay? So you got to be really careful on what information is shared with a step parent or a grandparent when they're dropping off and picking up the child, okay? What I would recommend is that you create, a form or an agreement that if a step parent or if a grandparent is doing a lot of the dropping off and picking up from your program, that you have some type of an agreement that is signed by the biological parent giving you permission to disclose confidential information to those individuals. All right, whether it's accidents, incidents, developmental milestone checklist, basically any of the everyday communication that takes place between the school and the parent. All right. You got to be careful because, if you do share sensitive, confidential information and you don't have that permission from both biological parents that have decision-making authority, it could turn legal if the situation got nasty enough. All right? We don't want that to happen. Get that agreement that you can share information with these authorized pickups. That is the best way of handling it. This does come up from time to time. Here is a sample policy that I have drafted and I have used in a lot of programs and a lot of situations. You can craft your own. You can use this as a model. Use it as a starting point, whatever works best for you. But basically, the name of your facility, we prefer not to get involved in custody disputes. I always like it when you put that in your policies. The name of the facility will follow a court order exactly as written. If your family has a court order on file, the family must provide the facility with the most recent copy prior to enrollment. Please note, per state law, in the absence of a court order, both biological parents have equal rights. With this being said, it is imperative that all enrollment records are completed with both biological parents' information. A copy of the child's birth certificate may be requested at the director's discretion, okay, so that you can verify that the enrollment paperwork is filled out correctly. Okay, this actually happens more than you realize, that the enrollment paperwork is being falsified. In the event that a custody dispute takes place on our property, the local police will be called and asked to handle the dispute. Our employees will not be placed in the middle of such dispute. If a custody issue creates a risk for our facility, you have a right to terminate care. Okay? Really good policy, really good language. And I have actually been in some situations where this has been a separate document that is signed by the biological parents or guardians at the time of enrollment. So not only included in your policy manual, but in some schools, we've actually pulled this out and had it as a separate document. Whatever works best, whatever is needed for your program. The last thing that I want to talk about here is protection from abuse and restraining orders. From time to time, you may get some of these in your program where it may say something like, mom cannot come within 1,000 feet of the child, right? Something like that. When you get these, absolutely you need to follow them. Look at the document carefully. They typically will always have an expiration date. So you want to make sure that it is a valid and current protective order. And then mark your calendar for when it expires. 90 days before the expiration date, follow up with that family. Hey, we've got this protective order on file. I noticed that it's about to expire in a couple of months. What's the game plan? All right? So you want to make sure you stay on top of it. The other difficult thing about protective orders is that if you have a person that knowingly violates a protective order, you've got to ask yourself, what else are they capable of? Okay? So it might be that you have the difficult conversation, hey, you have this protective order on file. Just want to let you know, if this person shows up and they knowingly violate this protective order, it may lead to dismissal from our program. Because not only are you responsible for keeping that child safe, you're responsible for keeping everyone in your program safe. And if you have a person that knowingly violates a protective order, you got to ask yourself, what else are they capable of? Okay? You got to protect your entire program. So that's something else that you want to keep in mind. We don't see these very often. They do come around from time to time. Just want you to be prepared. All right. So that is our training today on custody issues and early education programs, including the expectations from the Child Care Minimum Standards. Again, if you have any questions about this training, please message me, call me, email me. If you need more information beyond the scope of this training material, again, reach out to me. We are here for you. If you have a particular situation going on in your school, give me a call, shoot me an email. I like it when you can schedule a Zoom with me. I like face-to-face conversations. If we can't do it in person, Zoom is a close second. I can give you a calendar invite. We can schedule a 30-minute coaching session, and I can help walk you through any situation that you've got in your program. We're available for that as well. All right. Thank you all so much for watching this video. You can complete your assessment now on our website to receive your certificate of completion. And I look forward to having you again in another training very, very soon. Take care, everyone, and keep it safe.